The twist in the Senzo Meyiwa murder trial, accused 1 to 4 want their charges dropped. Their lawyer, Malesela Tefo, says there's no evidence against them. He insists they should not have been charged in the first place. 5 people are on trial for the murder of the then Bafana Bafana goalkeeper. For more on this, let's bring in eNCA's Silindelo Masikane. Slee, so Advocate Tefo wanting the charges dropped. What was in the court papers today?
So we received, Annie, the court papers this morning in terms of an application that Advocate Malesela Tefo is going to make to the National Director of Public Prosecutions. He will be writing to her in terms of Section 6B of the Criminal Procedure Act to ask her, or request rather, to stay the prosecutions against his 4 clients, basically to drop the charges and release accused 1 and 2 who were actually not in prison at the time of their arrest. Accused 3 and 4 were actually serving sentences at the time in which Senzo Meyiwa was killed. And so in these court papers, Advocate Tefo goes into detail as to why he's no longer going to make an application with regards to jurisdiction. This is why we had actually had postponed proceedings to the 12th of July. He was going to file papers arguing that the Pretoria High Court did not have the jurisdiction to hear the matter. But in these court papers, he says that particular issue is actually null and void because, in fact, the manner in which this case just began was unlawful to begin with in terms of the confessions that were obtained from accused 1 and 2, implicating accused 3, 4, as well as 5. Also saying that there are issues around the manner in which the judge is handling the matter. He believes that he is being prejudicial against himself and his clients. Also saying that he believes that there's some collusion taking place between the state as well as the lawyer for accused number 5 in terms of delaying the trial and just making sure that proceedings are delayed by any means possible. Because at this point, we know that the trial itself is supposed to resume in September. But also in the court papers, Andy, he goes into detail around issues that he finds with the DPP of the South Gauteng High Court, that is Advocate Chauke, saying that he's actually corrupt, in essence, and saying that the unsigned indictment, which was introduced by Tefo, which actually implicates those in the House as being the ones who need to be charged. Chauke, with that particular document, had written to the court to say that it was meritless and that it was the opinion of a junior advocate. Tefo is then arguing that this is false information, and in fact, Chauke has no grounds to be saying such of the unsigned indictment. But let's just take a listen to what he said earlier to our colleague in terms of these court papers.
After we've found one of the statements under oath by the leading investigating officer under the case number 636, being Brigadier Kininda, whereby in paragraph 3, it's alleging that we say investigation which resulted in evidence under oath revealed that the victim was murdered as a contractual assassination or a hit rather than a robbery or robbery gone wrong. And further say, evidence under oath revealed that 6 suspects actively participated in the planning and execution of the contractual murder of Senzo Meyiwa at the directive of Kelly Khumalo, close quote. So this led us to write a letter to need a further particulars from the state that we became aware now from this affidavit of Brigadier Kininda that the murder of Senzo was contractually made. There was a contractual involvement. So now we needed the disclosure of that contractual document that was entered into allegedly between our client and Kelly Khumalo. So the state in the response, they say, no, the affidavit that you went through of Brigadier Kininda is not before the court. We say, no, how on earth you say the affidavit is not before the court? Well, the same affidavit you do have at the state. Advocate Valo, you have the affidavit of Kininda, Advocate Musholola has got the affidavit of Keninda. So now what is that the affidavit is not before the court? We don't understand the interpretation of Baloy to say the affidavit is not before the court.
Slee, where are court proceedings as things currently stand?
At this point, Ali, court proceedings are stalled in terms of the trial itself. We know that the trial will resume for about 2 weeks in September and then another 2 weeks in November. And that's due to the availability of counsel, but also because Advocate Mshololo for accused number 5 had asked for a postponement to be able to go through docket 375, which is the second docket opened in 2019 that was investigating those in the House for defeating the ends of justice. And so what we were expecting, though, was that DEFO was going to file jurisdiction papers arguing that the North Gauteng High Court did not have jurisdiction, but as you've seen in terms of the turn of events, instead he's going to be making an application and writing to the NDPP to have the charges against his clients dropped instead. And we were expecting to resume with arguments in terms of the jurisdiction application on the 12th of July. So I think, of course, come the 12th of July, we should know what kind of a decision the NDPP would have made following receiving the letter from DEFO, because in his papers to the court, alerting them of his intentions to write to the NDPP, he's given the NDPP 7 days to respond in terms of what he will be writing to her. And so on the 12th of July, I think we will be ventilating this particular issue as opposed to jurisdiction.
Oh, thank you very much. Silindelo Masikane, of course, following the Meyiwa trial for us.